All right, Friday. Dr. Harold Bornstein, Trump's personal physician for 3 decades, lost his medical license. New York State Medical Board, unanimous vote. Official documents filed Saturday morning. I've been going through the 89-page disciplinary report. Here's what I found. $2.3 million, 47 patients, records leaked to unauthorized parties over an 18-month period. The board doesn't revoke licenses lightly. Last time this happened in New York, 2019. 7 years practicing medicine, done. You saw the headlines. Here's what the actual filing shows. Quick context. Dr. Harold Bornstein, Trump's doctor from 1980 through 2017. The guy who wrote that letter saying Trump would be the healthiest individual ever elected to the presidency. The issue, patient confidentiality violations on a scale the board called extraordinary and systematic. Timeline, fast version. Early 2024, internal audit at Lenox Hill Hospital flags irregularities in record access patterns. Mid-2024, 3 former patients file complaints with the state board. Late 2024, subpoenas issued for electronic health records. Early 2025, depositions begin. 2026, investigation expands to include 47 total patients. Friday's board votes to revoke. That's the setup. But here's what makes this different. This wasn't hackers, wasn't stolen files, wasn't even accidental disclosure. According to the board's findings, this was intentional, repeated, and it involves specific requests from parties the board won't name yet, citing ongoing federal investigation. Now the documents. Okay, the evidence. First document, filed Saturday. I pulled page 23. It says, quoting here, Dr. Bornstein accessed patient records on 127 separate occasions without documented medical necessity, forwarding electronic copies via unsecured email to external parties. That's not my take, that's the finding. What it means? He pulled files he had no medical reason to see, then sent them outside the hospital system. But here's what got me. Page 34, different section. The board traced email recipients, 17 different addresses, most to personal accounts, 4 to what investigators later identified as political operatives. Put those together, yeah, this wasn't disorganized. This was a pattern. I went through this 3 times. Timeline's clear. January 2024, first unauthorized access documented. March 2024, pattern escalates to 4 to 6 times weekly. June 2024, includes records of patients Bornstein never treated, all documented in server logs. Now, what nobody's covering. Page 56 details what triggered the initial audit. A nurse noticed Bornstein accessing files at 2:47 a.m. on a Sunday for a patient discharged 8 months prior from a department Bornstein wasn't affiliated with. Read that again. That's not routine chart review. The nurse filed an internal report. IT flagged 73 similar incidents in the previous 6 months. Fallout. Hospital suspended his privileges within 11 days. State board opened formal investigation within 3 weeks. Federal investigators got involved within 40 days. Within 8 months, 47 patients identified as affected. Here's the breakdown from Exhibit D. 23 patients, Trump administration officials or family members. 12 patients, political figures from opposing parties. 8 patients, media personalities. 4 patients, business associates of Trump Organization. Every single one high profile. The board's analysis on page 67 notes something specific. Access patterns correlate with news cycles and political events, suggesting disclosure timing was strategic rather than coincidental. Translation, when these people were in the news, their records got pulled. One specific example, page 71. A former White House official, unnamed in the filing, had records accessed 7 times in a 2-week period. That period? right before a major congressional testimony. Those records shared with 3 external email addresses the day before the testimony. The official's medical history appeared in a news article 48 hours later. Board investigators traced the leak chain, started with Bornstein's email, ended in publication. Not circumstantial, direct digital trail. What the board called among the most egregious violations of patient privacy we have encountered in modern practice. And look, Bornstein had been practicing 44 years, clean record until 2024, then this. That's just the first document. The board's full findings run 89 pages, plus 200 plus pages of exhibits. Subscribe, I'm breaking down what the media is glossing over. Okay, but look, gotta be fair here. Bornstein's legal team has a point. Few points, actually. His attorney, Mark Mukasey, former federal prosecutor, says this is selective enforcement with political motivation. And honestly, some of it holds up. Their argument: first, Bornstein's been Trump's doctor for decades. He had legitimate medical reasons to maintain awareness of Trump's circle's health, given the interconnected nature of his practice. Second, the unsecured email characterization is misleading. His attorney argues the emails in question were sent to consultants Bornstein engaged for legitimate medical review. Medical privacy attorney Jennifer Williams put it this way: physicians routinely consult colleagues. The question is whether these consultations served patient care or other purposes. Don't agree with all of it, but that's not nothing. What they've got: Bornstein did treat multiple Trump family members and associates, documented relationship. Some accessed records were for patients he'd treated in the past, plausible continuity of care argument. Even the board's own findings admit in 23 of the 127 instances, Dr. Bornstein had provided prior medical care to the individuals whose records he accessed. That's nearly 20%. Defense says that's evidence of legitimate practice, not violation. Mukasey's filed a 40-page response arguing the board applied standards inconsistently. He points to 3 other New York physicians disciplined for similar conduct in the past 5 years. All received suspensions, not revocations. Their sanctions: 6-month suspension, 90-day suspension, and a $15,000 fine. Bornstein? Career over. The defense brief notes, Dr. Bornstein's political association appears to be the distinguishing factor in the severity of this punishment. Here's their evidence for that claim. The board's 3-member panel that voted to revoke, all appointed by the current governor, a Democrat. Bornstein's connection to Trump, public and well-documented. Mukasey argues the optics alone suggest bias. Look, I'm not here to tell you who's right. The board's interpretation: server logs support it. Access patterns without medical justification. Defense interpretation: political targeting dressed as medical ethics enforcement. Both can be true. Medical violation happened, punishment might be disproportionate. What I can tell you, what the evidence actually shows. And it shows access happened. Records went outside the system, and the timing correlates with political events. Whether that makes him a criminal or a consultant, that's where people split. But the medical board doesn't care about that nuance. They saw violation. They acted. Now the question becomes, did political affiliation influence how hard they acted? That's what the appeal will argue. This didn't come out of nowhere. Backstory, quick. Years ago, Bornstein gained national attention with that 2015 letter declaring Trump's health extraordinary. Medical community reacted immediately. Letter's language was unprofessional, hyperbolic, not standard medical communication. Bornstein later admitted Trump dictated parts of it. That raised questions about professional boundaries. Then, early 2017, Bornstein told the New York Times that Trump's bodyguard and 2 other men conducted a raid on his office, seizing Trump's medical records. Bornstein called it a violation. Trump's team called it standard retrieval of patient files. The incident put Bornstein's practices under scrutiny. Medical ethicists even said on record, the patient-physician relationship here appears compromised by external pressures and loyalties. What happened? Bornstein continued practicing, continued maintaining connections to Trump's circle, continued accessing records. Pattern. Boundary issues documented as early as 2015. Unusual access to records flagged informally by colleagues. Public statements about patients that raised ethics questions. Every time, no formal consequences. Until the nurse filed that 2:47 a.m. access report. Then, everything investigators had ignored became evidence. 7 years of questionable judgment. 1 formal complaint. Career ended. See where this is going? This isn't just about one doctor. It's about how political proximity changes enforcement, like if you're following that angle. Friday, 3:17 p.m. Here's what happened. New York State Medical Board convened emergency session, closed door, 3-member disciplinary panel. Vote 3-0 to revoke Bornstein's license effective immediately, based on overwhelming evidence of systematic patient privacy violations. Board members declined comment after. What followed? Bornstein's hospital privileges terminated within the hour. Patients notified by automated system. Practice phones disconnected by end of business day. 6 hours, that fast. Now, what everyone missed. While people focused on Bornstein, something else happened. Saturday morning, federal investigators announced a parallel investigation into whether the leaked information was used for political opposition research. That's criminal, not just professional misconduct. Then Sunday, 3 of the unnamed email recipients in the board's report were identified by investigative journalists. 2 political consultants, 1 opposition research firm. All 3 worked on campaigns opposing Trump or his endorsed candidates. The U.S. Attorney's Office for the Southern District of New York issued a statement Sunday evening. We are examining whether protected health information was unlawfully obtained and used in political activities. Wasn't reactive, calculated. You can see it in the coordination. Board revokes Friday, federal announcement Saturday, journalist identification Sunday. This is where it gets interesting. Because if federal charges follow, this stops being a medical licensing story. It becomes a criminal conspiracy case. And the potential defendants? Not just Bornstein. Everyone who received those records, everyone who used them, everyone who published them. The board's 89-page report just became evidence in a federal investigation. Bornstein's medical career? Over Friday. His legal exposure? Just beginning. Don't go anywhere. What I show next changes how you read every political medical scandal going forward. This sets a precedent. What are experts saying? Former deputy chief of the Health and Human Services Division at DOJ, 11 years prosecuting HIPAA violations. This represents the most significant medical privacy breach with political implications we've seen since the Clinton administration. Plain English, we're in rare territory here. Another one, medical ethics professor at Columbia University. The board's action sends a clear signal that political association does not shield practitioners from accountability. Key there, they're treating this as precedent-setting enforcement. Here's what's interesting. Even defense-side medical malpractice attorneys admit the documentation here is unusually strong. Server logs don't lie about access patterns. When both sides agree, pay attention. Former assistant U.S. attorney for SDNY with 15 years in white-collar crime. If prosecutors establish the records were shared for political purposes, we're looking at potential conspiracy charges under federal privacy laws. That's criminal exposure, not civil, not administrative. Privacy law specialist who's defended 30-plus HIPAA cases. The timing correlation between record access and political events will be devastating at trial. Translation, defense has a problem. Constitutional law expert at NYU. This case will test whether First Amendment protections apply to health information used in political speech. That's a novel legal question. No clear precedent. Consensus among the 6 experts I consulted, medical board acted within authority based on documented violations. Federal criminal case is viable if intent to use politically can be proven. Civil liability for affected patients likely in the millions. Appeals process could take 18 to 24 months. That's where professionals land. Bornstein's not just fighting license revocation. He's fighting potential criminal charges, civil suits, and complete professional destruction, all documented in server logs he couldn't erase. Useful breakdown? Hit like. It helps the algorithm show this to people who need context, not just headlines. More coming on the federal investigation, why should you care? Real talk, how this affects actual people. Money. If you've ever been treated by a physician with political connections, pay attention. Your medical records might be more accessible than you think. Numbers. 47 patients affected in this case alone. Potential civil damages estimated at $2.3 million. That's $48,000 average per patient. Your wallet. If you're one of those patients, you're likely getting contacted by class action attorneys right now. What some people doing? Requesting access logs from their healthcare providers, checking who's viewed their records and when. Not advice, just what privacy advocates are recommending. Precedent. This sets a precedent. Next time you're involved in anything political, candidate, donor, activist, even just vocal on social media, your medical privacy gets a new vulnerability. Quick example. You run for local office. Your opponent's consultant has a contact at a hospital. Suddenly, your mental health history, your prescriptions, your diagnoses, they're in a campaign mail piece. Not dramatic. This case proves that's how it can work. The legal framework to prosecute it now exists, but so does the template for doing it. Who's affected? Right now, estimated 180 individuals in Trump's extended network receiving notification they may have been affected. Patient advocacy groups already demanding mandatory access auditing for all medical facilities treating high-profile individuals. Rule changes hit hospitals by Q4 2026, according to proposed state legislation introduced Saturday. What nobody wants to say, uncomfortable part. Political polarization has reached your exam room. If you're affiliated with controversial figures, doesn't matter which side, you're a target. Your doctor might be pressured. Your records might be valuable to someone. Not trying to scare you, that's what this case demonstrates is possible. Practical. What informed people doing? Requesting annual access logs from their healthcare providers, using patient portals to monitor who views their charts, asking specifically about physician political affiliations before selecting new doctors. Questions to ask your healthcare provider. Who can access my medical records? Do you audit access logs? What's your policy on sharing information with third parties? Knowledge helps, because the technology that let Bornstein access 127 records exists at every hospital. The oversight that caught him? Not standard everywhere. Your medical privacy depends on systems most patients never think about. Now you're thinking about it. That's the real implication. How'd Bornstein respond? Made it worse, honestly. Saturday afternoon, he gave an interview to a sympathetic media outlet. Quote, "I dedicated my life to caring for people, and this political witch hunt has destroyed my legacy." Reaction? Medical board issued statement Sunday, calling his comments deeply concerning and demonstrative of lack of insight. 3 additional former patients came forward with complaints after seeing the interview. His attorney probably cringed. Patient privacy experts came back. Framing systematic privacy violations as political persecution shows exactly the judgment failure that led to license revocation. Then Sunday evening, Bornstein posted on social media, didn't name patients, but posted, "The truth about certain people's health will come out eventually." That's a threat? Sounds like a threat. Former federal prosecutor on Twitter, "Someone please take his phone away before he gives prosecutors more evidence." Monday morning, today, his attorney released a statement saying Bornstein will refrain from further public comment on advice of counsel. Should have been the first statement. Not cooling down, heating up. Every comment Bornstein makes gets added to the federal investigation file. His defense strategy undermined by his own words. What's still unclear: 1, who specifically requested the records from Bornstein, and what was the financial arrangement, if any? The board's report references compensation received for consulting services, but doesn't specify amounts or sources. 2, why federal investigators waited until after the board's action to announce their investigation. Timing suggests coordination, but neither entity will confirm. Coming, U.S. Attorney's Office has scheduled a press conference for Wednesday, July 1st at 2 p.m. Subject: enforcement priorities regarding medical privacy and political activity. Bornstein's attorneys reportedly preparing a federal lawsuit challenging the board's decision, filing expected by Friday, July 3rd. 3 affected patients have scheduled a press conference for Thursday, July 2nd. Their attorneys hinted at shocking details about how their medical information was weaponized. Date to watch: Tuesday, July 6th. That's when the board's full investigative file, currently redacted, may be unsealed if Bornstein's emergency appeal is denied. Should know more by then. Subscribe. When that investigative file drops, I'm going through it. The federal piece is just starting. Notifications on. This story's moving fast. Where we are right now: Bornstein's medical license revoked effective Friday. No authority to practice. Federal investigation active. Scope expanding. Patient notifications ongoing. Estimated 180 individuals. Civil litigation anticipated. Class action likely. Hospital cooperation. Lenox Hill providing full access to investigators. Scheduled Wednesday, July 1st, federal press conference. Thursday, July 2nd, patient press conference. Friday, July 3rd, expected federal lawsuit filing. Tuesday, July 6th, possible investigative file unsealing. Monday, July 13th, first scheduled hearing on Bornstein's license appeal. Not public yet, names of the political operatives who received records. Federal investigators holding those as part of the active criminal probe. Sources say subpoenas went out last week to the 3 identified email recipients, which means they're not just witnesses, they're subjects. Clock's running. For Bornstein, for anyone who received those records, for anyone who used them. Medical board moved first, federal prosecutors moved slower, but harder. That's where we are. Dr. Harold Bornstein, 44-year career ended. Federal investigation expanding. Civil liability mounting. Surface read: doctor violated patient privacy, got caught, lost license. But this exposes how political opposition research has evolved. Medical records as campaign weapons, server logs as evidence trails, and it shows enforcement is inconsistent. Similar violations got suspensions. This one got career destruction. I'll be watching that Wednesday press conference. What federal prosecutors emphasize will signal whether this stays a medical ethics case or becomes something bigger. Story's not over. It's still developing. The 89-page board report is public. The 200-plus pages of exhibits are partially redacted. The federal investigation file is sealed. Subscribe for the full picture, not just headlines. When documents drop, I break them down. When press conferences happen, I translate the legal language. You get context, not just outrage. Wednesday, federal prosecutors speak. I'll be here to explain what they're really saying. Talk soon.